This is part 4 of our 5-part series on contingency planning that should be included in every trust, but more often than not is overlooked by the attorney in the drafting process. Why do you want to plan for contingencies? Let me tell you, because life has a way of throwing curveballs, and Murphy's Law will kick you in the butt every time it has the opportunity. And so if something were to happen in the lives of your beneficiaries from the time that you execute the trust till the time that you pass away, it's nice to know that many of the contingencies or the life's curveballs that could happen to your beneficiaries are already contemplated and planned for in your original trust document. So that is the reason our trusts are often 60 to 80 pages in length versus 15 to 20 that other attorneys and other law firms may give you. We've already gone over the possibility of death, disability, or lawsuit for your beneficiaries. This one is similar or related to the lawsuit, but it is divorce. So if one of your beneficiaries is in the process of getting divorced or maybe thinking about filing for divorce, during the estate administration process, our trusts are flexible and your successor trustee has the opportunity or the authority, I should say, to hold off on distributions or convert the trust into some sort of a discretionary trust, which we'll talk about in part 5. But the idea is that if your beneficiary is in the middle of a lawsuit and there's an attorney on the other side of the table, whether they be a general lawsuit or a divorce, which is what we're talking about here, even though, at least in Florida, most of the time, inheritances are not automatically not part of a marital separation agreement or not part of marital assets to be divided during a divorce. I've seen nasty cases where the attorneys will just throw spaghetti at the wall and they will try to attack the inheritance money and force the other side to just spend a bunch more money on their attorney arguing and having hearings over the fact that this inheritance money should not be considered a marital asset and therefore not subject to equitable distribution during the divorce proceeding. It's just easier if the money doesn't show up. As soon as the divorce is over, we unlock the padlock and we hand them their inheritance money, and they are off to the races without having to spend extra legal fees or attorney's fees in defending their inheritance against a future ex-spouse. If you like this information, follow me for more and stay tuned for part 5. Have a great day.